exactly how much time had elapsed between the time that the proof had been closed and this issue was raised. A juror named Mr. Castleman brought to the court's attention that he believed he had a relationship with the family of Mr. Jeremiah Wade, who was one of the victims in this offense. This is another shooting, and one young man was killed. Mr. Wade was paralyzed. Mr. Castleman came into the courtroom when the trial court was made aware of this and said that, excuse me, that he had worked for several years and had a close relationship with the Gerald Wade that he believed to be related to Mr. Jeremiah Wade. And he believed that because he had seen several people in the gallery during the trial that he knew or took to be Mr. Wade's family, and he somehow made the connection after basically the entire trial had already taken place. It's page 55 of the record in volume 4, and of course the court will review that, I'm sure, in great detail, but Mr. Castleman is asked by the trial court not once but twice and saying, you've had this long-standing relationship with Mr. Wade, you believe that Mr. Wade is Mr. Jeremiah Wade's relative, and you were close, do you think that would cause you to be biased? And he says yes. And he asked again, sort of, I think, taken aback, and he said, you would be biased. And Mr. Castleman said, yes, I would be biased. And so then the trial court follows up and says, well, do you think you could be fair to both parties? And he says, yes, I can be fair. And then, which is, again, somewhat difficult from the record to tell exactly what happened, Mr. Castleman is asked if the parties in the gallery, the trial court specifically points to the people that Mr. Castleman had recognized thinking they were related to Mr. Gerald Wade, who was related to Mr. Jeremiah Wade. And the trial court makes the determination that Mr. Castleman, the people that he thought were Mr. Wade's relatives were not actually Mr. Wade's relatives, and therefore it's a non-issue. That he recognized somebody who wasn't who he thought he was, and therefore he was going to leave him on the jury. That, well, A, doesn't sound like a very sound procedure to me. B, doesn't make any difference. If Mr. Castleman says that he is going to be biased in favor of Mr. Wade and against Mr. Gleaves, whether or not he recognized the correct person in the gallery or not doesn't make any difference whatsoever. So, the trial court's procedure in trying to determine whether this was a necessitated excusing Mr. Castleman or not was unsound, to say the least. Also, the state argues in its brief that no prima facie case has been made here that Mr. Castleman should be excused. I have a hard time conceiving of a situation when a juror repeatedly says that they're going to be biased, regardless of the fact that they then said they could be fair, how that fails to make a prima facie case. And at the moment, again, the record is not entirely clear here because of the timing, but it was close to the time when they had gone back to deliberate. I believe that the alternate jurors had been excused, but I don't know, I still think it was a realistic possibility to have used an alternate juror at that time. I don't know, perhaps they went home and immediately or took out their phone and started looking on the internet and do everything you warn jurors not to do because they weren't going to be on the jury, but obviously it could have been voir dire about that issue. The trial court was still in a position to rectify this issue at the time that it was brought to the trial court's attention, and then essentially elected to say, those folks aren't who you thought they were, so this issue is a non-issue. And of course, ignored essentially that Mr. Castleman said he would be biased and said, well, he said he could be fair. So obviously the court knows the case law here. I mean, Mr. Gleaves is entitled to a fair and impartial jury. And the record has, point blank, a juror saying that they would not be fair and impartial, or at least would be biased, though they do say they could be fair. So again, I would say that that is an abuse of discretion on the part of the trial court. Both procedurally, the procedure was unsound, and as well as the substantive result was unsound, as well as having a remedy. I mean, if this had been a day-long, they'd already been deliberating for a great deal of time, and we didn't even know where the alternate jurors were. But again, the way I read the record without the timing being specific is this was a situation that arose fairly quickly after they retired for deliberation. So respectfully, I would say that this is not the way the trial court should have handled it. It did result in someone on the jury who said that they would be biased towards the state's witnesses, in favor of the state's witnesses, and therefore, presumptively against the defendant.
But as I understand it, this juror was in the courtroom being questioned by the judge.
Correct, yes.
About who do you think these people are, and he heard and saw the people and then heard the conversation whether or not who you think they are.
Yes.
The jury was there for that.
The juror, if I recall exactly the way that it happened, Mr. Castleman was brought in and the issue was raised, and he said, these ladies in the front I think they're related to Mr. Gerald Wade, and I remember him, and he's a friend of mine from work for a long time. And then I think he went back or was taken out of the courtroom, and the trial court inquired, exactly who are these two people, and I think that they might have been relatives of another victim. I think it came to be the case that they were not related to Mr. Wade. So then Mr. Castleman was brought back into the courtroom and said, I don't remember the phrase exactly, but something that these folks are not who you thought they were, and therefore, since you say you can be fair, I'm going to leave you on the jury.
The judge
made that.
Said that.
Yes,
okay.
yes. So when the judge questioned about who those women were, I don't believe Mr. Castleman was there at that moment, but yes, that was the play-by-play, I believe. So again, I think this has resulted in Mr. Gleaves having a biased juror on his jury, and I think that basically creates a presumption of unfairness. I mean, obviously, the jury is not obligated to tell us how that they reached their verdict. There was no polling of the jury afterwards. No testimony was raised at the motion for a new trial or anything of that nature. But again, he's entitled to a fair and impartial jury, and that's not what he has here. My secondary issue that I wanted to talk about today was his sentencing. Mr. Gleaves was convicted of a second-degree homicide, an attempted second-degree homicide, as well as various other offenses, as well as having a firearm in commission of these felonies. The trial court basically maxed him out for as much as they could. He received a 49-year sentence in total, the vast majority of which was at 100% release eligibility, making the two major offenses consecutive to one another. I would argue that, one, the trial court did not go through the proper procedure, but two, the case law that I've cited at length in my brief, which is still good case law, in order for a trial court to make sentences consecutive on the basis that the defendant engaged in dangerous conduct, it has to be something more than simply multiple offenses that were dangerous. And of course, there's no way to argue these weren't dangerous offenses. Of course they were. But the fact that they were dangerous, the fact that he used a firearm, the fact that they're some of the most serious, and therefore, consequently, the General Assembly has attached some of the most serious penalties to. Again, Gray, going back to the 70s, but also Wilkerson in the 90s, say you need something more than simply having multiple dangerous offenses that are inherently dangerous. You need, and I am quoting here, well, maybe I won't quote because I won't find it in time. But basically, that there has to be something appreciably greater or worse about this defendant in this circumstance than simply he engaged in multiple acts that were dangerous. And I think that's exactly what we have here is multiple acts that are dangerous, but otherwise Mr. Gleaves was just over his 18th birthday. I don't believe he had any criminal record as an adult. If he did, it was only a misdemeanor, if that. Another thing that one of the reasons that consecutive sentencing is permissible, and one of the reasons it should be and is reserved for the worst offenders, is because those folks have proven that they are not amenable to rehabilitation, and or that they've made somewhat of a career or livelihood engaging in criminal behavior. Well, he's 18 years old. He doesn't have a criminal record, has not really even had a chance to get much of a criminal record, and to say that an 18-year-old is not amenable to rehabilitation, I certainly hope that's not the case. So the factors that generally support consecutive sentencing are absent from Mr. Gleaves on a personal level. And so I would argue that the trial court erred and abused its discretion when it made consecutive sentencing because there was nothing in particular about his circumstance that warranted it. Obviously, again, these are extremely serious offenses, but that's why the legislature has made these punishable by some of the more severe sanctions that the courts can give. And so something more is needed to make it consecutive, and I think that's absent here. And I will say, again, I argued this to this court before without success. I don't believe a rote recitation by the trial court of, 4035, 102, and 103. I have considered all of the purposes of sentencing. I have considered that this sentence is no greater than necessary. There's nothing in the record that I see, other than reciting the facts of the case, that show that the trial court actually did that. It's almost like when there's an admonition of rights, that the trial court just reads it off of a sheet to say that they've done it, so that this court, it will be insulated from any real review. I don't feel like that's what the trial court's supposed to do. It's supposed to.
And the Supreme Court says that that's okay. And so we are all following the law.
I think the Supreme Court says something like that, Your Honor, respectfully. I think they said that there's no magic words. I mean, there's nothing that the trial court necessarily needs to say, but other case law says there has to be some justification for the sentence that's reached. So I think there's more than simply reading the statute is necessary. And I don't think that the trial court did much more than that, other than essentially saying, it's bad to shoot people, so I'm going to put them in jail for as long as I can, without saying it. So if there are no questions, I'll just reserve the balance of my time.
Thank you, Mr. Rance.
Thank you.
Good morning, and may it please the court, Caroline Weldon on behalf of the state. On Labor Day weekend 2018, the defendant and his roommates made their way to a house party. After they parked in a church parking lot nearby, the defendant and his roommates saw another group in the parking lot, and an argument ensued. During the argument, the defendant withdrew a weapon and opened fire, striking Mr. Roper and Mr. Locklear, who were also armed, but who had not displayed their weapons. Mr. Roper succumbed to his injuries, and Mr. Locklear survived, but is paralyzed. Beginning with the defendant's...
So Mr. Wade was not a victim in this case?
That's correct, Your Honor. Mr. Wade was one of the state's witnesses. He was one of the victim's friends. He was in their group that night. So I'd like to clarify a few of the details surrounding this juror issue. The trial court handled this issue of possible juror bias exactly as this court would want. After both sides rested, but before the jury had begun its deliberations, one of the jurors sent a message to the trial court's law clerk that he had made a mistake, meaning he himself, the juror, had made a mistake. The trial court immediately convened a conference during which the juror told the trial court that he used to work with someone named Gerald Wade, and he believed that this former coworker, who he had not seen or spoken to in 6 years at the time of the trial, could be related to this state's witness. So that is the sort of connection that the trial court was left to contemplate based on this disclosure from Mr. Castleman. It remains unclear, well, several things remain unclear. Whether or not this juror actually did work with a relative of this state's witness, and then what the extent of that connection would be. As counsel noted, Mr. Castleman, in trying to explain this relationship, possible relationship to this juror, he did say that he was biased, but the record shows that he was using the word bias as a layperson would use it, and that they're saying, I might know this person, and I want to make sure that the court understands I may know this person. And the trial court carefully explored how he may know this person if he did through this former coworker, and asked the juror, even if you did used to work with the state witness's relative, can you still be fair? And the juror said, oh yes, I can be fair. And based on this extended conversation, which I believe was in chambers, the trial court concluded that Mr. Castleman should remain on the jury, that he was able to be fair and participate fairly, just given the attenuated alleged relationship between these two men. And again, the defendant cannot show not only that the men had no relationship, but that this had any impact on Mr. Castleman's ability to participate in deliberations and to be a fair juror throughout this process. At no point did Mr. Castleman say, I believe that I worked with Mr. Wade and I know that I can't be fair because I hated him at work or because he was my best friend at work. That's not shown in the record at all. He's simply stating, I used to work with someone who shares that last name, and that is more or less the extent of the conversation in chambers. So from that, the trial court very reasonably decided that that juror should remain on the jury and participate in the deliberations that followed. If there are no further questions about that juror issue, I'd like to turn to the defendant's arguments as it relates to his sentence. The trial court did not err by imposing an effective sentence of 49 years confinement. All of the sentences that he received were within the appropriate range for a range 1 offender. And it's important to note that the defendant received partially consecutive sentences. He could have received more time, but he received partially consecutive sentences, or they were aligned partially consecutively. The trial court should not have applied enhancement factor 6. That was an error, and we concede that. However, the trial court also found that 3 other enhancement factors did apply, and the defendant poses no challenge to the application of those enhancement factors, and all of those were appropriate given the facts of this case and the rest of the information introduced at the sentencing hearing. The defendant, I believe it was 2 weeks prior to this argument and shooting in the parking lot, had actually been sentenced to diversion. And his sentence for diversion stemmed from charges of attempted possession of a firearm, marijuana, and theft. And the trial court seemed particularly bothered by that during the sentencing hearing, noting that the defendant had just been given the grace of that sentence, likely due to his young age, and despite having just appeared in court and receiving such a sentence, chose to arm himself and go to a parking lot on the night in question and open fire. And of course, after he opened fire, he did not attempt to render aid, but fled and disposed of the weapon, leaving both victims in the parking lot, one who died and then one who is paralyzed for the rest of his life. So while he may not have had any publishable record at the time that this crime occurred, he had just been sentenced to diversion. And the trial court expressed its concern about the defendant's apparent inability to correct course after receiving such a sentence just before these crimes occurred. Turning now to the alignment of the sentences, an extended sentence was necessary to protect the public for this offender, and the trial court expressly made that finding during the sentencing hearing. Again, this was an argument that began over some back and forth in a parking lot between 2 groups. The testimony at trial showed that there was some light pushing, there was maybe some loud voices, but it was really the defendant who escalated the altercation and opened fire and fired, I believe it was nine times at the other group in the parking lot. And especially given that the defendant had just been sentenced to diversion, to arm himself and then to spray bullets about the parking lot over such a minor argument, I think the trial court felt that this really was someone who should not be out and about, that if this is how he's going to conduct himself over such a minor altercation in the parking lot, that that's not someone that society would want to receive a lesser sentence. And as it relates to the severity of the crime, again, these were all young people in the parking lot that night, and one of those young men is dead and the other is paralyzed. So the trial court considered the severity of those injuries and fatality in finding that the sentences should be aligned in that manner and that the defendant should receive a lengthy sentence in confinement.
To make a Wilkerson finding, the sentencing court has to find both
Yes, Your Honor.
factors, correct? And the trial court did make a finding that an extended sentence is necessary to protect the public against further criminal conduct by the defendant. Correct?
Yes, Your Honor.
In this case, that defendant's criminal conduct was this case and I guess 2 weeks earlier where he got in the version for that. Is that right?
Yes, Your Honor. That's as far as the defendant's criminal history, the sentencing hearing was lengthy, and during that sentencing hearing, the defendant also gave some testimony that he had been involved in some sort of botched robbery at some point. It's unclear as to when exactly that botched robbery occurred, but he did testify to that during the sentencing hearing. And then there was additional testimony by one of the victim's mothers that the defendant had posted rap videos in which he said something to the effect of, "I won't leave another witness next time."
Well, I guess what I was getting at is that the trial court, sentencing court, made both Wilkerson findings.
Yes, Your Honor. Yes, it did.
Okay.
And it was a robust and lengthy sentencing hearing where the trial court very thoroughly canvassed who the defendant was at the time that this crime was committed, and the trial court considered everything that it needed to in reaching this decision. And it noted that the defendant was a young man at the time that he was sentenced and at the time that he committed these offenses, but given all of the information that was introduced at the sentencing hearing, concluded that the defendant needed to be incarcerated for a lengthy period of time. If there are no other questions, I'd ask this court to affirm. Thank you.
Thank you.
Your Honors, I did feel like maybe a little bit of context given what the General just said. My recollection was that the robbery situation for Mr. Gleaves was that he was shot during a robbery, that he was the victim of the robbery. The trial court did somehow use this as a basis, saying that he was involved in an incident with a firearm, but I don't think that the sentencing hearing bore out that he was the one with the firearm on that occasion. Essentially just that he was, nothing good happens after midnight kind of argument by the sentencing court. I do apologize. It is Mr. Roper and Mr. Locklear who are the two victims here, and Mr. Wade was merely a witness. I've got a lot of folks running around in my head this morning. Another thing that I think the court should know, of course, the court will read the facts, but the other group that included Mr. Roper and Mr. Locklear was armed that evening when this encounter happened. And then after the shooting occurred, they attempted to hide the firearm and then lied to the law enforcement about ever having one. Mr. Reyes, who was a witness for Mr. Gleaves at trial, said that one or both of these gentlemen had produced the firearm and during this argument and pointed it at him. And this was what precipitated Mr. Gleaves' conduct. Obviously, the jury did not believe that. But it was certainly more, there was more context than simply there was a shouting match and Mr. Gleaves decided to start shooting people. There definitely were, the other parties were armed, and they definitely attempted to conceal this from the police, both by hiding the firearm and not telling the truth about it. So it is more nuanced than that. As far as the term bias, the record will speak for itself. I don't think that this court or the parties should try to say, well, Mr. Castleman said that he'd be biased, but what he really meant was this. I mean, again, the record speaks for itself. If the trial court had said, Mr. Castleman, do you know what the word bias means? And he gave an inappropriate or inaccurate definition, then perhaps. But the trial court asked twice and said, do you think that this relationship with Mr. Wade would be biased, would cause you to be biased? And he says, yes. And then he said, so it would cause you to be biased? And he said, yes, I would be biased. So again, I think that we're bound by what the record says, not an interpretation of what Mr. Castleman might have thought the word bias means. The question was asked and answered repeatedly, and that was the answer that was given. And again, yes, he did say afterwards he still could be fair, but I think we are stuck with what the record says and not interpreting what we think Mr. Castleman meant when he said the term biased. So unless there's any other questions, I think that'll be all. Thank you.
Thank you, sir. Court thanks you both for the arguments in this case today.